to have an investor and somebody who works with a very large tech company here on the panel on this topic. And since we're already pressed for time, I'll just get right into it. I think what we'll try to do is we'll just talk about two main areas and sort of repeat some of the themes today. One is just the experience of starting up and how to manage risks and Agnesh's views on what do investors look for. And second is what sort of the constantly changing legal environment means for fundraising and just generally investor sentiment in the sector. So my first point will be to Yagnesh, right? We see at least even in early stages, and you're probably the exception, not the rule, very heavy documentation. How do you sort of would go about engaging with founders when you're looking at the documents, you're looking at how to manage risk, how to raise money, and approach just fundraising at the early stage?
Thanks, Arjun, and thanks, ET Legal guys, for having us. Fundraising, as you would know, pretty much, the headlines are generally for larger deals. We are a pre-seed VC stage fund. We invest founders who are bootstrapped. When I say bootstrapped, it's basically you start your business, you have an idea, you've worked on it for a while, and you take the risk of jumping into it full time. That's exactly where we come in. We are a first check fund. So we deal with founders, at the very basic grassroots level. Mostly techies nowadays, but also non-techies, also mature founders who are from college, founders who have, at various stages in jobs in some good companies. When they start up, they come up with an idea. They're focused more on the business, right? Not on compliance and legal stuff. They're not very good at it. So the idea of, when we started, the whole idea was to make it simple. So how do you make fundraising simple? So that's where we were inspired with, there's an accelerator VC in US, I think all of you would know. It's by the name Y Combinator. Y Combinator popularized the safe notes in the US. And back in 2013, and by the way, Y Combinator has funded some of the large unicorns that have come out from the US. So we thought that if you really have to make a difference to the Indian startup ecosystem, you've got to get something like this here, right? So we took that opportunity. We Indianized the safe note. We call it iSafe Notes. We rolled it out. It's a simple 5-page document. Founders really don't have to understand too much of legality. They can straight away and one-on-one sign up with the investors. You don't have a 50-page SHA to sign an agreement and take funds. I think that's what makes the breakthrough. That's what we were trying to do. And this, we are happy to say this is really taken off. And this is what we feel will transform the early stage ecosystem. Yeah. I think we'll wait for you to discuss more on it.
No, absolutely. In India, we still haven't seen a lot of standardization that exists, right? You will see the NVCA standard drafts, which basically make a lot of terms very easy. Market understands it. There's very limited negotiating points. And instead, sometimes people don't have the benefit of seeing an iSafe note, which is like 4 pages and, limited rights, limited warranties, because, people don't really want to spend that much time negotiating documents. They just want to get it up and running. But when your founders then go for subsequent rounds and they see the kind of documentation that exists in the market, what is your sort of advice on how to navigate that ecosystem?
Yeah, so that's part of our program. When we fund early stage startups, there's a detailed program that we have. It's called Home Run Series. We get them educated on the next steps, right? When they go out, raise the larger round, this is what they should be aware of. They should know that the larger investor comes with a larger check, and hence they will want to protect their investment, right? And those are the rights that come in, the exit rights, the affirmative voting matters, and the likes. It's important for them to understand. So as a part of our program, we educate founders about these things. But while we educate them, we advise them strictly not to deal with these on their own with the investors. Yeah. We do advise that, take legal help. We have a battery of lawyers here working with us. We tell them go seek legal advice, because if it's a meaningful round, then your rights do matter. It's an outcome. You've worked so hard to create value in the company. Founders should be rewarded for the value, right? And some of the things in the SHA can easily take that away. So we do that quite often.
Correct. No, that's And that sort of brings me to sort of Varsha, because you've seen this journey not only just at a very early stage, but now a very, very mature company at MPL. And just picking up from your Yagnesh's thread, right? We don't have a concept of market standard per se, right? Where say in the US market, there's sort of annual reviews of what are market terms and what are not market terms. We haven't reached that sophistication yet. So, and sometimes there's always this competing interest between closing the fundraising round quickly because the founder wants to raise money, as opposed to the in-house counsel or external counsel telling them about the risks. So there's always that balance of interest between maintaining, doing something quickly but understanding the risk and going ahead. And we've all seen how, just in the interest of efficiency, if we end up signing things, they come back and bite us. Like my experience sometimes has been that people have signed up to exit terms, promoters giving some wide support on exit kind of obligations, and then when it's actually going to IPO, the company ends up bearing a lot more cost than what its competitors would have. So have you seen people navigate that, and what do you see sort of the role of internal counsel then becomes?
No, I think the risks that you flagged are very real. The founders and the larger business team of the startup is always going to be focused on the next step, the growth, whatever they have planned with the money it's supposed to be coming in. And as the in-house team or even external advisors, the role of naysayers or talking about the future doom and gloom, so to speak, comes on to us. Though I think at the end, we are the ones who eventually have to walk a more practical path, where the only solution is to intrinsically understand what the company is about, what the technology is about, because that's only when you can advise the founders about what is a practical risk to take. You can't take all the risk off the table. Your investors aren't going to be happy in that case. But it's a risk that you'll have to be able to live with, and more importantly, they have to be okay to live with, because legal teams may come and go, but they are there.
Correct.
And that's something we need to break it down to them, help them understand that. And that clarity, which can only come with a very ingrained understanding of the business.
No, absolutely. And I mean, often sometimes your role becomes that this is an issue, but we'll probably pick it up in a later round, and
very easy to just defer it to later.
Yeah.
But yeah.
But remember to pick it up when the next round does happen, because otherwise it becomes a concern. No, and another area, and especially for in-house teams, it becomes with investors, especially in challenging businesses like yours, where it's finally coming around, right? Like where finally we're getting clarity. There's been a lot of conflict on the business model and between states and centers. Your role also becomes to sort of communicate exactly what the business is, because founders may have a vision, but that vision is not completely aligned to the regulatory framework. So you have to sort of break it down, explain it, and help people understand exactly. And if that communication is not clear, sometimes counsel for investor teams may end up raising risks that both the investor and founder are on the same page, but legal teams often are not, and then it becomes another issue to overcome and another hurdle to overcome to get the funding done.
Absolutely. I'm sure you've seen this as well, where during the term sheet, everyone was on the same page because the business teams talking to each other. But the moment you're at the SHA stage, suddenly disputes crop up because no one had thought through on those points, and it's up to the lawyers to figure that out. I think on that, talking about the regulations for the industry, there have been challenges. Pay-to-play has taken some time to be accepted. I think finally we're seeing the central government making some movement on this, and this is something we're actually welcoming, because the law inevitably follows technology. That's the rule of disruptive technology. But I think the great step that's happened is that they're essentially setting guardrails over here without really blocking out innovation. And that, I think, has been managed through very extensive consultation. I think they've been doing consultations for over 6 months at this point, taken inputs from various different departments within the government itself, not just industry folks. And that shows in the draft that was finally released. And we're hoping that same direction continues in the final version. But yeah, I think eventually understanding the intent of the government and the kind of regulation they may, or rather their concerns, and helping the team position that, where it's internal communication, even marketing, because eventually everyone sees what you're putting out there. It's not just about your investors. And then thereafter communicating the actual real risks or the risks that can be mitigated to the investors internally boils down. That measured decision on what to set out, how to set it out, and how to convert that business vision into a real problem and statement to which you have solutions set out already is, I think, where the legal team can be very helpful.
Correct. I mean, I think when you said that sort of technology always precedes sort of what the law says, or follows. I mean, sorry, the law always follows what the technology does. How do you end up investing? I mean, Yagnesh, for you, right? There are so many investments you'll be making where, the Indian legal framework is either antithetical or at least it's slightly controversial. So how do you take those bets? And what do you do? How do you work with founders when you're taking those bets?
Yeah, it's a very interesting question. I come from a finance background. I'm almost half lawyer. I've done so many SHAs in my life, so understand the legal implications. But, when we started funding startups, when we did this, and we interacted with a lot of these early stage guys, somebody's coming with a disruptive idea. Of course, we have to understand whether it's on the legal side or not. But whenever things are gray, okay, that's where the discussion is, right? If it's pure black and white, then it's very clear. Then there's no discussion.
There's no opportunity.
It doesn't
there.
go ahead. But where there's gray, there's something that, like for example, RBI came up with these payment aggregator guidelines. 3-4 of our startups were on the gray side, right? Now, at that point is very critical to advise founders to deal with how it is, or even if new deals are coming to us. What we try to do is, we take of course, we have an in-house legal counsel with us. We consult them. But where there's a gray, even the legal mandate is not very clear. If the deal is good, if it's disruptive, we go ahead and take a call. Because, if you do not fund startups who are coming up with disruptive ideas, and as, Varsha was pointing out to you, that legislation will follow, the technology and the disruption cannot stop.
Correct.
Now, for that not to stop, we have to start funding ideas. If we wait for a detailed legal opinion from a counsel and then, it takes months, it won't really work out. So we take that call, we take that leap of faith, we invest in the startup, and then we figure things out, right? Founders always figure things out. They are nimble, they are fleet-footed. They can figure things out later on. You can pivot, you can do multiple things. So that's where the whole point comes in. So beyond the point, it's just a leap of faith you take. So that's my take on how we take decisions.
No, absolutely. And once the founder says that we'll figure it out, it usually comes to somebody like Varsha to figure it out then. Yes. So at that point, how do you get around? Because often in many of these situations, there is either no law, and there is or there is a gray in the law, and it's there, or there are conflicting sort of legal positions across. And a lot of there is a lot of context that may not be directly applicable, but in other situations, right? Like for example, digital lending is something that's now seeing some amount of heat and fire. But RBI has always sort of has taken strong action against usurious practices, and then they've always been focused on it. They've even taken actions against sort of listed companies, right, with SK's Microfinance in the past. So how does it practically that you navigate it? What is the approach that teams now have to take and rely on outside counters, rely on what you think, and bring in a business understanding to some of this?
I think to a certain extent, the Agnesh's sentiment will continue where everyone is taking that leap of faith, but you will, as a lawyer, when they come to us to figure it out, you have to go by the larger intent and purpose that the government will eventually try to address. Where with digital lending, it was to protect the most vulnerable sectors.
Correct.
It's not for probably you and me, who may take it on a whim, or just to try the app out and probably pay it back within a minute. It's for the most vulnerable ones who really get sucked into that debt trap. And there's nothing that they can do about except actually put down very harsh restrictions.
Correct.
That being said, I think you and I were also discussing where they did let the companies set out their own boundaries. You obviously had some who pushed it a little too far. You had some who toed the line, kept a very, I would say, black and white moral position at least, if not a legal position that was there. Centering ideal around the company. And those are the ones you see continuing to some extent now. Correct. It's not like the entire industry got wiped out.
Correct.
And the same would apply when you're looking in any other sector, right? Correct. Where you look at the intent. You will find some basis in judicial positions or even in just your law commission reports. And those will eventually form the basis for what the government comes up with. And the key thing would be to not ignore that, to just not treat them
Correct.
as arbiter or just one more report that was never actually acted upon, because 10 years later, 20 years later, it may still come about, it may still get acted upon. And those decisions may be what differentiates you from the ones who pushed it too far.
Yeah, no, and increasingly, for in-house counsels and even for their external counsels, you're moving from a role of just like advising on the black and white or the yes-no of the law to also setting out context and also understanding what ecosystem you survive in, right? So increasingly, it's also becoming important of who are your stakeholders, how do they feel about this business, what are their issues, what are they not. So, it will be very helpful to understand how it applies in sort of a sort of context of, gaming, especially, right?
Okay, I can give the example of actually a different territory, because since in India, we're actually at a far advanced situation. We did launch in the US, which is in 2021, and that's a new sector. The kind of judgments and rulings that we have here, which guided us when we were launching in India, are not as clear over there. You have precedents that are about 30 years old, very outdated, don't account for technology, or are just very vague, because obviously didn't have the kind of clarity we have now. And even there, this is eventually what came to guide us on what we would determine to be okay for the business to do and what we would rule out entirely. For instance, I think there are certain games where they clearly, social casino games are treated very differently over there. The amount of time, addiction by players, whether it's just time, if not money, is already treated that has very advanced treatment over there. So games which foster addiction actually need to have more stronger protections over there, which is not really advanced over, though we've made strides in other sectors. So that, I think, is what you'll still have to look at, which comes back to my earlier point, or an instance of my earlier point, where you still have to go by the larger sentiment and what you have available, and not discount it just because it's not absolutely binding on you right now.
Correct. No, and Ignesh, like just coming back to what you were saying, right? A lot of the sectors you invest in have some of this regulatory flux, and while it's been slightly cooperative, especially with some of the central departments for the sector MPL, Varsha's organization operates in, right? In many youth, it's antithetical, right? Cryptos for one, sort of, there's been strong pushback, and even for sort of fund activities with overseas investments or investing overseas.
No, so as a fund, we are an India domiciled fund, so we always fund startups who are domiciled in India. Of course, some of these flip over to the US
Correct.
because of business reasons, investor reasons. I've always told founders that unless you have a very strong reason to flip, do not flip, because there's enough capital here. Everything's here. But for example, a crypto or a blockchain, any protocol that you're working on, Indian laws have not really advanced to the stage where they can deal with these kind of startups. In those cases, a flip is justified. But just a general point, it's slightly out of context, but here we have a lot of law firms here. My simple request is, I'm sure they're doing it, but when you're talking to founders, first time you opened account and you're trying to advise them, understand their business and try to be sympathetic about the business, right? While you're obviously going to advise them on law, you are the law experts, you need to have a sympathetic view about it, because they don't come informed. That's the job of the lawmakers, right? And the legal guys who are advising on it. So you've got to really understand the business, and sometimes it's not very easy. It's complex, like Varsha said, right? You got to see what's good for the business. So from an ethics perspective, from a business must-do perspective, you should advise them, because it's going to carry out very far. Like, the founders are going to take very important steps. So will be the investors funding the startup. So I think that is a responsibility on the whole legal ecosystem here that we have.
Just ties back to I think one of the earlier statements earlier in the day, right? Like legal teams are sort of moving down from the basement to sort of the top floor, right? And they're increasingly closely involved in some of the decision making and sort of product decisions. So, anything.
Just a quip that we have in MPL as not a cost center, but a value creator. And I think very common across legal teams, where we're not simply just there to stamp your contracts for you. We actually do a little bit more than that.
Correct. And how has your perspective of outside counsel changed in that view, right? Like, do you still see them as people who are basically saying this is the worst doom and gloom, and then you sort of graduate the risk going ahead? Or do you also increasingly see them working as sort of collaborators in saying that, this is the risk, this is the amount of risk that we can take, these are the consequences? So what is it that you were saying?
And we do use a lot of external law firms. the point is, while my job is to know the business in and out, there I rely on them heavily to stay on top of the legal developments, which is something to do both. It needs to superhuman abilities, and not everyone has that. So that's how we balance it out, where I have someone else keeping a tab on the law and the developments, and or even just keeping an eye on the chatter on what may be coming. And I can focus inward at that point on the business, on the founders. So that's how we play a balance, and I don't think external counsel are going to be not required at any point in time. I think we very much need them.
Correct. No, anything else to add?
Sure, I mean, we're happy to take questions.
Yes, I was just about to intervene to humbly request you to please wrap up because we're already out of time, but we can surely take one question, just one question, very quick question.
Since we are talking about safes and iSafes in India, sometimes founders tend to give out a lot of dilution to the investors, in especially the seed and the pre-seed rounds. So as a lawyer, how should I convince them and how should I navigate navigate that founder from the situation where they are diluting shares in the lure of that money? So
yeah, well, a good question. This is a common question that we address day in and day out, right? Sometimes founders would have come in with already a highly diluted cap table. Now, those are obviously bad situations for founders. While the money is important, everybody agrees to that. And I mean, it's a position, right? Whether do you have multiple choices or you just left with one investor. That's a big role to play in all the contracts that go in, all the rights that go in. Because the investor, typically, whatever we say, they are going to kind of, corner you out and probably get a few extra rights. Idea is the commercial part. This is a commercial question, actually. It's not a legal question. But the way the lawyers can actually contribute is you negotiate certain contractual clauses in such a manner that if the founder performs at a certain later stage, you can claw back your equity, right? Let's say I've already lost 20% at seed. I would have lost 30%. I should have lost 20. There can be some reclaw, it's called clawback mechanisms, it's typically very common. You've got to put in that clause if the investor sees growth happening and you put those milestones out in the agreement, the founders get back a little bit of equity that they've lost. These are some of the things that are very common, and I just gave you one example, but those are things that you can work with.
Yeah, no, I mean, we've also seen bonus share issuances come in at later stages.
Bonus, clawbacks.
Yeah, where sort of investors will say that, just to incentivize, and Tesla is a great example where, there was
at the point of agreement signing and money coming in, maybe that's not the, you cannot address it at that point. But maybe at a later stage, right? You put in a clause saying 1 year milestone, whatever time frame, you get bonus shares to the founders, and founders get their little bit of their equity back.